Thank you, Senior Counsel. I now submit submission 3. The Juniper Point Eatery did hold a duty of care to all patrons. However, this duty had not been breached, nor has the 2 elements of causation been satisfied. Your Honour, in considering breach, probability of injury is also given consideration pursuant to Section 9.2 of the CLA. Expanding from my Senior Counsel, the case of Bolton and Stone offers a clear example of this provision in effect. In this case, it illustrates that a plaintiff who had been struck by a rogue cricket ball had been given no liability in circumstances where a ball had only been hit out of the grounds 6 times in 28 years. Your Honour, the defendant had been the licensee of the premise for 8 years, and throughout the duration of that time, there had been 0 prior instances of violence between customers. Section 10B of the CLA further states, the fact that the risk could have been avoided by doing something in a different way does not in itself give rise to liability. This is given further authority in Graham Barclay Oysters and Ryan. Lastly, pursuant to Section 46C of the CLA, a person who is intoxicated does not in itself increase or otherwise affect the standard of care owed to that person. Your Honour, further to breach failing, it is our assertion that the 2 elements of causation pursuant to Section 11.1 of the CLA has not been met. Namely, that the breach of duty was a necessary condition of the occurrence of harm, and that it is appropriate for the scope of liability to extend to the harm caused. In establishing the first element, the but-for test was applied in the case of Barnet and Kensington Hospital. In this case, no liability was given to the negligent actions of the hospital, as it was deemed regardless of those actions, the victim would have died due to the nature of the poisoning. In similar circumstances in Adil's Palace, the lack of increased security did not give rise to liability, as it was deemed that the increase in security would not have changed the outcome of the shooting in that case. Your Honour, it is our assertion that the same is applied to our case. Regardless of what precautions the defendant may have taken, it would not have changed the outcome of the offender returning to the premise 15 minutes later and choosing to inflict harm via stabbing the plaintiff. The second element of causation, Section 11.1b, asks whether it is appropriate for the scope of liability to extend to the harm caused, whilst Section 11.4 states, for the purpose of deciding the scope of liability, the court is to consider whether or not and why responsibility for the harm should be imposed on the defendant. Your Honour, it is our submission that the scope of liability in the car park should not extend to the defendant for harm caused to the plaintiff, given authority for similar circumstances already exists in Adil's and Barnett's, and that this extended scope may yield a floodgate of litigation to the defendant for all instances occurring in the car park. Further, pursuant to Section 12 of the CLA, in deciding liability for breach of duty, the plaintiff always bears the onus of proof on the balance of probabilities, any relevant facts to the issue of causation. I now submit submission 4. The Juniper Point Eatery should not be held liable for consequential psychological injury sustained to the plaintiff. Your Honour, the Queensland jurisdiction dictates that we must follow common law for authority in this matter. The case of Annette and Australian Stations confirms that the plaintiff must establish that they are suffering from a recognised form of psychiatric injury. In this case, this has been met through the clinically diagnosis of depression. However, Your Honour, the common law allows recovery for a recognised form of mental harm, provided it is A, consequential upon physical injury, for which B, the defendant is liable. This is given authority in NADAR and urban transit. Your Honour, it is clear from the facts that the plaintiff suffers from a recognised form of psychological injury, and this was a direct consequence of the physical injury sustained. However, as per our previous submissions, it is our assertion that the defendant is not liable to the physical injury and thus also not liable to the psychological injury sustained. Your Honour, in conclusion, given the plaintiff is claiming consequential psychological injury as a result of harm inflicted rather than pure psychological injury, and it is our submission that although the defendant held a duty of care to all patrons, this duty of care had not been breached to extend to the scope of the car park, nor have the two elements of causation sufficiently been satisfied, thus rendering our defendant not liable to the harm suffered by the plaintiff and resulting psychological damages. As such, counsel for the defendant respectively requests that the defendant be held not liable to all damages. Thank you.